The defendants in this case, that being James Crumbley and Jennifer Crumbley, are each charged with 4 counts of homicide, involuntary manslaughter, contrary to MCL 750.321. The prosecutor alleges that the defendant's 15-year-old son, Ethan, shot and killed 4 Oxford High School students with a gun that they purchased for them. Specifically, the complaint in the warrant alleges that the defendants caused the death of Madison Baldwin, Anna St. Juliana, Tate Muir, and Justin Schilling by committing the following acts or acts in a grossly negligent manner, to wit, storing his or her firearm and its ammunition so as to allow access to the firearm and ammunition by his or her minor child, or the grossly negligent failure to perform the following legal duty, to wit, failure to exercise reasonable care to control his or her minor child so as to prevent him from intentionally harming others, or from conducting himself so as to create an unreasonable risk of bodily harm to others, knowing that he or she has the ability to control his or her child and knowing of the necessity and the opportunity to do so. The issue to be determined by this court is a probable cause standard. In other words, after a preliminary exam, is there probable cause to determine that a crime was committed and that the defendants committed the crime? The complaint in the warrant alleges that the defendant's behavior violated Michigan law, which provides that any person who shall commit the crime of manslaughter shall be guilty of a felony punishable by imprisonment in the state prison not more than 15 years or by a fine of not more than $7,500. Because the statute does not define manslaughter, the court must look to common law and case law for guidance. It is well established that involuntary manslaughter requires a death caused by the defendant without legal justification or excuse while the defendant was acting in a grossly negligent manner or while committing an unlawful act which was inherently dangerous to human life. That is quoted in People v. Moscow, 170 Mishat 340, a 1988 case. In 2018, the Michigan Court of Appeals addressed the common law basis for involuntary manslaughter and the threshold for gross negligence. In People v. Head, 323 Mishat 526, a father was convicted of involuntary manslaughter after his 10-year-old daughter accidentally shot and killed his 9-year-old son with a gun that the defendant stored loaded in an unlocked closet. Apparently at the time, the 10-year-old was attempting to reenact a scene from a violent video game they were allowed to play unsupervised in that same room. The court held that allowing children to play unsupervised in a bedroom in which a loaded gun was stored amounted to gross negligence on the part of the father. The Court of Appeals went on to hold that involuntary manslaughter is a catch-all crime for any homicides that do not constitute murder, voluntary manslaughter, or an otherwise justified, excusable homicide. In its opinion, the court noted that the requisites mental state for the defendant is gross negligence, which means wantonness and disregard of the consequences that may ensue. To prove gross negligence, a prosecutor must show 1, knowledge of a situation requiring the exercise of ordinary care and diligence to avert injury to another. 2, ability to avoid the resulting harm by ordinary care and diligence in the use of the means at hand. And 3, the omission or the failure to use such care and diligence to avert the threatened danger when to the ordinary mind it must be apparent that the result is likely to prove disastrous to another. That is cited in the Head case. In the Head case, the court determined that while the defendant was not personally aware that his child would accidentally shoot and kill his other child, or that he was aware that he knowingly created that possibility, the defendant did disregard the risk and the danger of 9 and 10-year-old children playing unsupervised in a room where a firearm was accessible. In fact, the court stated, quote, "It goes without saying that a loaded shotgun poses a danger to young children who are not being monitored by an adult. Defendant had the ability to avoid the harm by exercising ordinary care and diligence. By allowing his young children to play unsupervised in a room where he kept a loaded, readily accessible shotgun, defendant failed to use the requisite care and diligence. He failed to avert a threatened danger where the result was likely to prove disastrous to his children. Therefore, we conclude that there was sufficient evidence of gross negligence. That court also addressed the factual and proximate causation elements of involuntary manslaughter when it held that it was beyond question that factual causation existed, but for the defendant keeping a loaded shotgun in an unlocked closet of a bedroom where the children were playing without supervision, the shooting would not have occurred. Additionally, the court held that the child's accidental firing of the gun was reasonably foreseeable and thus proximate causation existed. Consequently, the head court affirmed the defendant's involuntary manslaughter conviction. In People versus Harris, the court stated the following: the crime of involuntary manslaughter does not require that the defendant be personally aware of the danger or that he knowingly and consciously create the danger. The test only requires the danger to be apparent to the ordinary mind. That's 159 Mich. Act 401, 1987, also citing People versus Seeley, 136 Mich. Act 168. In Harris, the defendant was charged with murder after he confronted his daughter's ex-boyfriend with the gun, and upon racking the gun, a shot discharged, and the defendant immediately stated that he did not mean to shoot the victim. At the exam, the magistrate determined the shooting was an accident, so he dismissed the murder charge. On appeal, the court held that the magistrate abused his discretion by dismissing the case entirely because evidence presented at the exam supported a probable cause finding of involuntary manslaughter. The court relied on the OR factors, which this court previously cited, and further held that the test for involuntary manslaughter under a gross negligence theory only requires the danger to be apparent to the ordinary mind, and the killing certainly could have been avoided by exercise of ordinary care and diligence by the defendant in the use of a firearm. Therefore, in this case, after hearing extensive testimony, as well as evidence and reviewing and viewing extensive exhibits, the court finds that the deaths of the 4 victims could have been avoided if James and Jennifer Crumbley exercised ordinary care and diligence in the care of their son. Specifically, the court finds that the prosecutor has shown by a probable cause standard that 1, the defendant's son, Ethan Crumbley, presented a danger to the community. Number 2, that danger was apparent to an ordinary mind. Number 3, that the defendants, James and Jennifer Crumbley, neglected to diligently address and or divert that danger. And number 4, that the danger resulted in the 4 deaths of the young children at Oxford High School. There was extensive testimony that Ethan Crumbley was certainly a troubled young man, and that the defendants had knowledge of that situation. But they purchased a gun, which he believed was his, and that he was free to use. Therefore, the court is binding the defendants over as charged. Any argument on that?
Yes, Your Honor. Your Honor, you've heard extensive testimony, you've seen exhibits. And although the court is binding James and Jennifer over, we are asking that the court reconsider the bond. Your Honor, Ethan Crumbley is incarcerated. James and Jennifer have given this court, they have a minimal criminal history, as we've gone over previously. We've gone through the factors with the court before. There's no substance abuse issues. There's no failure to appear issues. Judge, we're asking that you reduce the bond, allow them to be released. As the court is aware, we've had numerous issues with meeting with our clients while they're incarcerated due to COVID restrictions at the jail. It obviously impedes on their ability to meet with us, to develop their defense, Judge. So I'm asking the court to reduce their bond to $100,000, 10%.
Response?
Thank you.
I'm sorry, you have the same motion as it relates to Jennifer Crumbley?
Yes, Your Honor, I'll just steal what Marielle says. We'll just go with that.
Thank you, Judge. From the people, there's been no changes in their status. There's no reason to amend bond. We addressed bond on January the 7th of this year. 6.106 discusses bond and conditions. This court set the bond initially upon arraignment. This court considered a number of factors, including the information contained in the square sheet, as well as their alleged flight at the time the warrant was issued. On the bond hearing, the prosecutor and myself addressed the likelihood of conviction as well as other factors. The last two hearings we've had in this case have only added to that, Judge. We have provided this court with a snapshot of the evidence that will be at trial. The court has already determined the probable cause does exist as to both defendants on both theories of involuntary manslaughter. As I stated, January the 7th, these defendants will be convicted. They will go to prison. Their guidelines start at prison. We will be asking for a prison sentence. There's no reason to amend that.
This court did hear extensive argument and testimony during the course of a bond motion that was held on January 7th, 2022. After hearing the testimony and also viewing the exhibits in this case, the court finds that there is absolutely no reason for it to change its position as it relates to bond. The court finds that in accordance with the factors set forth in MCR 6.106, that the defendants in this case are facing very serious charges, that there is a flight risk given their prior behavior. Therefore, the court is not going to amend the bond. It is denying that motion.
Thank you, Your Honor.